Okay, we'll get started. Good morning, everyone. I'm Annalee Patel. I'm an associate attorney here at Farmer Law. I'll be stepping in for Jeremy, who cannot present just due to personal circumstances. So be aware that I recognize so many names, so I'm excited because I know their H-2 program is quite intensive and very structured. So I'm excited for you to get more answers, and the goal is to also give you a lot more transparency. So just as a note, we'll have our presentation posted for you after the meeting. So please don't feel like you need to take any extensive notes. First, you'll have the presentation accessible, and second, you're always welcome to call me or reach out to your PLs and your teams if you have any specific questions. So at a glance, we're going to discuss the H-2 modernization final rule. There'll be an overview, the program-related changes, worker flexibility. We'll also discuss the green card pathway and just some takeaway points. There'll be a little bit of Q&A, but I believe for this session, since it's so case specific, we won't have a dedicated Q&A time space, but feel free to, again, reach out to me directly or your teams, and we'll definitely get back to you. To start off, I'm, again, Annalee Patel. I am kind of lurking in the background of a lot of your casework. A lot of paralegals come to me with all the questions as well as all the paperwork. So the JCPs that you sign, the 790s or PWDs, all of that goes through me. So anytime you have a question, typically if the PL can't answer, they'll loop me in. So if my name sounds familiar, it's just because I'm looped into all your correspondence. We'll be discussing the H-2 Program Modernization rule, and a lot of the rule itself stems into one, making the program a lot more efficient, two, standardizing the procedure. Just give me a minute while I try to disable my notifications for your sake. But anyways, pointing back to the H-2 rule, a lot of it points to creating worker flexibility, efficiency on your part as the employer, and ensuring that there's a little more room for discretion from the USCIS and DOL, and I'll touch on that in a moment. First, to start off, the main objective for the rule is to modernize both the H-2A and H-2B programs. It's to kind of simplify it, to strengthen the labor protections while ensuring there's flexibility for the H-2 workers, but also making sure that there's a lot of more program efficiency, whether it's coming from your labor certification process to the DOL adjudication, extending all the way through USCIS adjudication. This started implementation on January 17th, and we've been not slow rolling the process. We've actually been kind of monitoring every case. So every correspondence that you've all had, anything that was relevant to the rule, we've likely alerted you of that. So if you have had any changes or any variables relevant to the rule, please be comfortable knowing that we've likely already reached out to you. And then going forward, anything that we find pertinent will also be reaching out to you. So we're monitoring it on your side, and we're also monitoring on our side. Now, the direct impact of this rule is that the employers and workers under H-2A and H-2B visas are going to be uniquely impacted in specific ways that we'll touch on in a few slides. And then the new regulations, as an overview, touch on portability, grace periods, and the removal of eligible country lists. Moving on to program-related topics, we have the eligible country rules removal. That means essentially you can source H-2 workers from countries, for example, Indonesia or the Philippines or even India. These are countries that weren't previously on the eligible country list but are now available to source workers. What does that look like in our legal procedure? That is to be determined. The DOL and DHS weren't clear on if there's changes to the filing procedure. So as it stands, if you as an employer have a couple of employees/workers that you want to source from, for example, China, you would tell us and we would figure out whether we need to file a unnamed USCIS petition or a named USCIS petition. Remember, when we do a named USCIS petition, it means we're providing all the documents for each worker. And unnamed does not have that level of intensity. So usually what we're trying to see and understand from other practitioners as well as our own knowledge of USCIS is seeing when an unnamed is relevant and when a named kicks in, relevant to the eligible country removal. As soon as things get more clarity, just as a side note, as things become more clear on the practice side, we'll also make sure we update you. A lot of these rules, whether it's from the DOL or USCIS, overall, the Department of Homeland Security, tend to be vague. And we have to have that buffer time to use it, practice it, and then they come back to us with, okay, this is what the procedure is going to look like. So if it seems a bit vague right now, it's typically like this anytime a rule changes. Fear not, we're here, we know what the practice looks like, and we follow what the best procedure is going forward. So if you, again, have any questions when it comes to case specific issues, always feel free to let me know. In terms of USCIS compliance, in addition to the Department of Labor's authority to audit an employer's H-2 program participation, the USCIS now has power to also conduct inspections and compliance reviews. This could lead to more H-2 audits. I know there's several H-2A employers of ours that unfortunately had to experience what an audit looked like. And while that stage is usually handled with a notice and then potentially a request for additional information. And there's long periods where we just don't hear from the Department of Labor. We are now also expecting similar procedures from the USCIS, which is unfortunate, but again, is also why we try to boost so much about, hey, this is what's going to be complying under regulations. In the long term, that's what's going to be a bit better in terms of safeguarding your protections and also ensuring that you have the paperwork needed to hand over in an instance an audit is issued. There's also, in relation to this, a increase to discretionary power against H-2 employers with a history or a pattern of non-compliance. Typically, we can flag this on the legal side, or we've already flagged it to you. So if you're concerned, you're more likely going to be notified from the very beginning. And if you're not concerned, then that's okay. You've probably not been flagged by us. You've probably not had any issues. So just know that we're always monitoring these certifications. If you're asking for a new application and it follows your history of need, we usually don't have any cause to cause you to be alarmed. But if there is a history of applications that may be different year after year, we're going to start requesting, if we haven't already, paperwork to just prove why that need is changing and what the variables are that you're accounting for in making that request. As for H-2 fees, the petitioner, all of you, can now be reimbursed for voluntary or personal fees, such as passport fees. Before, the employer was liable for fees relating to the immigration process, primarily at large, but now you can be reimbursed for passport fees. So that's definitely a great step in terms of you getting small pockets of money over time, as well as there's now whistleblower protections for the workers. So similar to the H-1B program, when a worker has lost or failed to maintain status due to extraordinary circumstances, there'll be protections in place to evaluate that circumstance and see if that can be alleviated in a USCIS process. And now pivoting more closely to worker flexibility, we have a grace period rule change. So now going forward, before the certification start date, all H-2 workers have a 10-day grace period to enter the country before the period of employment or when the certification begins. So the key here is before that start date, there's that 10-day allowance now right before. And that allows the workers to enter the US, get reasonably set up in their work, their housing accommodations, understand their travel expectations, all that good stuff, so that there's less of a buffer period and less of a period, there's more allowance essentially for the employer to ensure their workers get here, one, and two, ensure when their workers do get here, there's less last minute hassle in getting them to be familiar with the land and the location. Additionally, after the certification ends, all H-2 workers have a 30-day grace period to exit the US or to transfer certifications after the period of employment or the certification ends. So this will likely allow more transfers and time to ensure that the change of status or an extension of status is granted or even in the works. And then lastly, all H-2 workers have a 60-day grace period following the end date of that H-2 employment. And this will either end at the period of the admission, which is on the date of the I-94, or at the end of your certification end date. So that will typically be case specific. I know I've already discussed this circumstance with some of you, when you have a worker with an I-94 and or a certification coming to an end and you're wanting to see if we can transfer or extend their status, just know that you can flag this to the legal team and then we'll make this analysis for you. So as long as you're kind of knowing the calendar days, 10 days before the certification, 30 days after, 60 days after, all you need to do is reach out to us and we'll start configuring and helping you create a strategy going forward. As for the portability rule, H-2 workers who want to work on one cert and then hop to the next don't necessarily need an approval notice anymore. Instead, we just need to file a bona fide petition. In this case, what a bona fide petition means for USCIS is filing a non-frivolous petition. So any petition that we've been filing for all of you has always been relevant to a need that you have because it's tied to a certification. That's great because we're essentially showing that you do have a need for the worker. So this is a pretty low threshold for us to meet as your representative. It's just going to require us to file that I-129. And as soon as we get a receipt of that, we're going to recommend that a worker can start immediately under this rule until we're advised otherwise, right? So right now, it looks good for workers to just pivot from one cert to the next at that filing date. And it also opens up you guys in terms of letting you guys have more access to your workers a lot quicker than waiting on USCIS to adjudicate. Additionally, in terms of the period of stay calculation, the rule's been changed from 90 days to 60 days. So to reset the 3-year period, the worker just needs to leave the US for 60 days to reset that clock back to the 3-year period. And how this looks in practice is we tell USCIS when the worker has left the US for 60 days, we provide evidence of that 60-day period away and then show them that they've entered the US or are waiting to enter the US. So a lot of that is the burden on our side to show the USCIS, just so you're all aware. It's not intensive by any means. It's just so we can open the door to USCIS knowing that, hey, a worker met the 3-year rule and now they can qualify to restart that 3-year period all over again. It should not be difficult. Before it was 90 days and now it's modified to 2 months. So that ideally will ensure your workers are still allowed to go home and see their families and such, but also be able to come back into H-2 status and restart that 3-year clock a lot quicker. Lastly, workers can't be penalized for leaving employment, i.e. absconding. Typically, for a host of you, we filed a notice of separation with the Department of Labor and or the USCIS. In that notice of separation, there are different categories to end the employer-worker relationship. One of those boxes was absconding, which was, just as a refresher, when an employee leaves without notifying you for 5 days, for at least 5 consecutive days. So now what the regulations say is those workers, even though they left without notifying you for 5 days and therefore have absconded from this job order contract, they cannot be prejudiced against having future H-2 employment. It's not going to necessarily impact a lot of you in terms of your petitions and having workers perform under your petitions. It may impact you in terms of feeling that, oh, hey, an H-2 worker left and that was a bit unfair for us, and then we couldn't fulfill a contract. In that instance, I understand it could be, you may feel unfair, but it is under the regulations now that they cannot be penalized for that. So just going forward, we will understand and sympathize in terms of any changes to your project timelines and such, but there will be little we can do or recommend for workers who do abscond. Now going to H-2 to the green card pathway. If an H-2 worker with a pending I-140 pursues H-2 employment, typically in the past, the I-140 causes red flags to the USCIS system. That red flag would then lead most H-2 workers to a denial on a renewed H-2 status. However, now USCIS cannot base a H-2 rejection on a filed I-140. So in this instance, what we'll now do is naturally still pursue H-2 pathways for workers who filed an I-140, but we will also now include documents from the worker. So if you're seeing your legal team ask you documents from the worker regarding ties to their home country, it's because that is now in the regulations to include. What it's asking essentially is showing proof that the H-2 worker has concrete evidence connecting them to their home country. For example, mortgage payments, medical bills, children still in Mexico or Canada or any other country. And that way, when we provide evidence, they as in USCIS have to adjudicate it with all that material at hand. Now, this also still means that a rejection can still be made for any other reason, but not an I-140. So that is great news for any of your workers who are pursuing both pathways. And we definitely expect to see some discretionary decision-making made by USCIS. It's still too soon to say how that's going to unfold in terms of how strict are they going to be with us providing evidence, how much evidence is enough evidence, all those details. So if I am communicating with you and I'm asking for at least 5 bullet points worth of documents, please know that I'm asking because I want to assure maximum approval likelihood as opposed to just trying to meet the threshold and try to just slide it through. Of course, if you have any questions about that, always feel free to let me know. Me and the IV team are happy to kind of consult you and ease any concerns you might have. Additionally, rather than USCIS, USCIS will consider the PERM certification or I-140 along with the filing of other documentation for the H-2 filings. So that just echoes what I said in terms of USCIS having to view the full petition and not just denying an H-2 petition simply because a worker filed an I-140. It's good news, and it's definitely something that I know a lot of your workers are pursuing, and I am hopeful that the procedure in place is the procedure that will remain without any modifications going forward. Second, it will become a responsibility of the H-2 petitioners to demonstrate that the foreign national has a foreign residence abroad and that they don't intend to abscond when filing a subsequent H-2 filing after a PERM or an I-140 has been filed. So this just brings all the regulations in the US in line with what consular practice has been. So typically when we've seen a worker go into administrative processing or a denial, we've noted that it's been because there's been an I-140 or a PERM process started for an H-2 worker. Now, like I said in the last slide, the whole picture has to be analyzed by the officer, and then a decision has to be made, not relevant to the filed I-140. It will be interesting. I do think this essentially means that there's going to be a consolidation of decision-making between consular agents and USCIS officers. So this is a big consistency measure between making sure that bridge between consular and USCIS agents are actually now the same. And now our takeaways for the modernization rule. Primarily, the goals of this from the Department of Homeland Security was protection and compliance, flexibility for workers, process efficiencies, and expanded protections. Under protection and compliance, there were new measures made to strengthen worker protections and program integrity for H-2 workers. And now there are clear strategies to prevent and address violations related to prohibited fees. In terms of flexibility for workers, there's extended grace periods and enhanced job portability for H-2 workers. And that's also a big win for all of you as employers because that helps enable the cert to cert transfers and also just those allowing workers to go back home for a little bit and then re-entering to restart their 3-year period is going to be a bit more seamless going forward. And also, the pursuing of permanent residency doesn't automatically disqualify H-2 workers from pursuing H-2 employment in the short term. There's also process efficiencies, such as removal of the eligible country list. And this is done to simplify the program administration. It's also not a provision that's clear in terms of how to proceed. So when we are filing the I-129s, for the short term, what we've analyzed is to file an unnamed petition for applicants of countries who weren't on the eligible country list before, but that is subject to scrutiny from the USCIS, right? So if we're then advised by USCIS, hey, file the named petition, even if the workers are coming from China who weren't on the eligible country list, then we'll have to pivot and do that. Either way, when you raise the information that you want to bring a worker from a country that wasn't on this list before and how to proceed, we'll tell you what is current to that time as we still monitor what's unfolding in the practice arena. And then lastly, there's expanded protections, which is essentially increased protections for whistleblowers and collaboration in inspections to ensure fair working conditions. This kind of goes back to the increased audit scope. We're seeing a lot more DOL and USCIS discretion when it comes to issuing an audit and the scope of that audit. So again, there's going to be going forward, we naturally were boasting and trying to ensure you are safeguarded with compliance, but now it's almost going to be you have to be in compliance. There's almost going to be very little room for us to find arguments in support of non-compliance or finding other ways to explain that non-compliance. In the past, if that's happened, then we'll have contacted you and talked about any paperwork that could be drafted and prepared to kind of bridge that gap. But going forward, if we have a certification, we're going to respectfully ask that we really adhere to that certification unless there's variables outside your control, like force majeure or economic circumstances. And that way we're, one, doing you justice by ensuring that you're in compliance, and two, protecting you in the long term in case you are audited. With that said, thank you. Again, we just want to note that we'll be sharing the presentation and we're happy to communicate for any questions about the modernization rule. A lot of our paralegals on both H2A and H2B team have been prepped and bit warned by me in terms of knowing how extensive and how far-reaching this may be for some of your applications. On the H2A side, I know you're all in the filing process right now, and then H2B, I know we're at the USCIS stage. So please know that if there is anything that we've already interpreted as a rule change, you've already been known. But that doesn't mean you can't ask me questions to prepare in the future. So always reach out to your PLs. They'll reach out to me and I'll either schedule a call or I'll also just jump in and email you. But you're also welcome to ask any questions at intake at Farmer Enterprises or call this number. And if you have any questions in terms of any ongoing filings, just feel free to message in that relevant email thread with whatever questions you might have as well. Thank you, everyone. I appreciate your time. And I also appreciate you taking your morning time, especially when I know it's busy in the middle of the week, to familiarize yourself with the H-2 modernization rule. We'll keep updating you as things become more clear. And I'm Annalee, and I'm sure I'll speak to all of you sometime soon. Thank you.